Good evening, everyone. Whenever we are preparing for any competitive exam, we always have a look at the syllabus. But it is always important that we solve the previous year's questions as well, because this gives us a clear idea as to what kind of questions have been asked previously. Today, we will be covering MPSC 2022 question paper for Assistant Town Planner. This entire question paper will be covered in 3 parts, out of which this is part 1. So without further ado, let's start solving the paper. Question number 1 is a match the following type of a question. Here you can say the sections are given in column 1 and the provisions are given in column 2. So this is a direct kind of a question. You just need to have a good idea about the act or the policy or the report that is in talk. Here we are talking about Right to Information Act 2005. So before we move on in detail of the question, all these documents are available free of cost online. So before preparing, you should always download all of these documents. So here you will be able to see the list of sections are given 21, 22, 23 and 24, and towards the left you can see the provisions in detail. So here 21 talks about protection of action taken in good faith. A is 2. 22 is apt to have overriding effect. 23 talks about bar of jurisdiction courts. And 24 talks about act not to apply to certain organizations, which is 1. So here 2, 3, 4 and 1 is the sequence. So 3 is the answer over here. So this is a very direct question taken from the act. You just need to know the chapters and the sections that the particular act talks about. Second question is on similar lines. We have sections and you have to match it to the provision. But the act that we are talking about in this particular question is Maharashtra Right to Public Services Act 2015. Let us look at the sections in the question 4, 5, 6 and 7. Section 4 talks about right to obtain public services within stipulated time limit. 4 is 3. 5, providing public services within stipulated time limit. So 5 is 4. Section C talks about monitoring status of application. Section 6 gives us the answer as 1, and section 7 is use of information technology for delivery of public services, which gives us the answer as D, 2. So the sequence over here is 3, 4, 1 and 2, which is giving me 3 as the correct answer. The next question is, every public authority shall publish the necessary particulars mentioned under section 4(1)(b), and you have to complete the sentence. Here you can observe that the name of the act is not given to you. So you should be so thorough with your acts and policies that you already know what act we are talking about over here. So in this particular regard, we are talking about RTI, and as already given in the question, we are talking about section 4(1). Let us have a look at the document. Section 4(1)(b) talks about 120 days from the enactment of this act to publish the necessary documents. So here the correct answer is 1. 120 days. Now, what necessary particulars are we talking about? It is very important whenever you solve any question paper, previous year question paper or any mock test, it is very important that you always look at the question properly and you always look at the options properly. And in your studies, you should make it a point that you take out all the keywords from that and study more upon that. For example, here, if we are talking about some necessary particulars, you should always have a look at what all particulars are we talking about. For example, here we have particulars of its organization's functions and duties. We are talking about the powers and duties of officers and employees. We are talking about the procedure followed, norms set by it for discharge of the functions, rules, regulations, instructions, statement of the categories of document that are held by it or under its control, and so on. So you should always make it a point that you cover the entire question properly. Okay, moving on to the next question. Now we are talking about a few theories in the coming questions. To start with, the first one is an economist developed the sector model in 1930s. So who is the economist that we are talking about? Option 1, Clarence Perry, E.W. Burgess, Homer Hoyt, or Harris and Ullman. So we know that sector model is a land use model. Okay, and along with that, we always study two more models, that is concentric ring model, sector model, and multiple nuclei model. As I told you, these are land use models. So it is revolving around the various land uses that we have. Starting with the center in the first one, and the second one is CBD, and then you have various other land uses, for example the transition zone, LIG, MIG, and the HIG or the commuter zone. And in this particular sector model also we have the various type of land uses with respect to the commuter zone, LIG housing, and HIG housing. Now why the difference then? In concentric ring model, it is argued that any city grows in the form of concentric rings and you have organized land uses accordingly. But in the sector model, it was argued that no city develops in the form of concentric rings because it is very restrictive in nature, and practically that is not what usually happens. So it was argued under sector model that any city will grow in the form of sectors or wedges, and hence the alternate name for this sector model is also wedge model. In multiple nuclei model, it was argued that like in concentric ring model or in sector model, we just have one CBD, the central business district or the commercial business district, which is the hub of all the economic activities or major of the economic activities in any particular settlement. So it was argued that instead of one, we can have multiple nuclei, as in multiple centers of commercial activities, and hence the name multiple nuclei model, which was given by Harris and Ullman. Sector model was given by Homer Hoyt, and the concentric ring model was given by Ernst Burgess, and hence this model is also called as the Burgess model. Now coming back to our question, the sector model was given by Homer Hoyt. We've already seen this. The correct answer is 3. Now what about Clarence Perry? So Clarence Perry has given us concept called as the neighborhood model. Okay, we'll come back to this later on. For now, let us move on to question number 5. Sir Patrick Geddes, known as the father of modern town planning, developed a new approach to regional and town planning based on integration of something called the Geddesian trio, or it is also called as the Geddesian triad. So the options are work folk place, work family place, city satellite region, or region city and place. So before we move on to this particular question, one thing that you should note, which is directly given in the question, is Sir Patrick Geddes was also known as the father of modern town planning. You can have a direct question like this also in your exam. Moving on to the theory that he is given, the trio is called as work, folk, and place. Now let us look into the details of this particular theory. Folk over here refers to the sociology aspect, or people, or you can say organisms. Work here talks about the work here talks about the function that the organism is doing. Okay, and place here talks about the environment in which the folk is working. So this is to do with sociology, this is to do with economics, and this is to do with the environment in which the folk is working. Okay, now why to study this in the first place? Patrick Geddes argued that whenever you have folk working in a place which is very suitable, very convenient, very comfortable for that organism or that folk, the work or the productivity or the functionality enhances. So this is the topic, this is the concept that he talked about under folk, work and place. Now, before moving on to the next question, let us talk about other concepts given by Sir Patrick Geddes, which is very important and can come in your exam. So, let us write down a few of the concepts given by him. The outlook tower, the valley section principle. He also gave us the concept of conurbation and he gave us two concepts, that is the diagnostic survey and conservative surgery. So your homework for the day is to look into all of these concepts in detail. Okay, now moving to the next question. In India, in Gandhinagar, residential sectors are planned on the concept of what? Option 1, neighborhood. Option 2, capital of Gujarat state. The third option is central place theory, or the fourth option is the garden city concept. So first of all, you should know about Gandhinagar. Gandhinagar is actually the capital city of the state of Gujarat. So when the Bombay province split into two states, Maharashtra and Gujarat, Ahmedabad was the capital during that time, and later on Gandhinagar was planned as the capital city, which is around 23 to 24 kilometers north of Ahmedabad. Okay, so it is the capital city of Gujarat, but here in this particular question, we are talking about the concept that it is based on. So the concept is going to be neighborhood concept. Okay, so the answer for question number 6 is 1. Now let us look at the other options as well. Capital city of Gujarat we've already discussed. What about garden city? So who gave the concept of garden city? Question number 1. Question number 2, are there any cities based on the garden city concept? And the third question that you can look into is, who planned Gandhinagar? So the planners of Gandhinagar are, let me write it down over here. H. K. Mewara and Prakash Apte. Okay, so you can make a note of this also. Many a times direct questions are asked with respect to the city and their planners. The next thing is garden city. Who gave the concept of garden city? Please type it in the comment section. And if you know any city that is designed on this particular concept, please let us know that as well. Yes, it was given by Ebenezer Howard, and a few of the cities planned on this particular concept is Letchworth and Welwyn. Now, the homework for you can be to know the planners of Letchworth and Welwyn. So, this is the way you should always do any previous year question. You need to cover the question entirely. Okay, moving on to the next question. The concept of neighborhood unit was originally published by whom? So we've already looked into this briefly. Clarence Perry, Homer Hoyt, Friedrich Engels, or Patrick Geddes. So we've already made a note of all the concepts given by Patrick Geddes, and the neighborhood concept is not one of them. So Patrick Geddes is gone. Homer Hoyt has given us the sector model. So that is also not the correct answer. Friedrich Engels is also not the correct answer. Friedrich actually worked a lot with Karl Marx, and he was a socialist thinker, and he believed that capitalism is very exploitative in nature and alienated to the working class. So there are a lot of concepts given by Friedrich Engels. You can look into that as well, but that is not the correct answer as far as your neighborhood concept goes. The answer is Clarence Perry. Now let us go to the map that we referred to earlier on. This is the neighborhood concept that was given by him. So the neighborhood concept says that a community living together should feel free and should feel safe in a neighborhood. So what has he done is, first of all the community centers, church and schools are placed at the center. The population, he says, should be so that for this particular population, one elementary school can be designed. Okay. Now, in the entire area, you will see a lot of residential spaces, but you will have green spaces as well. Enough green spaces. Okay. The next point to note in this is you will have the main roads, the arterial roads or the major roads or the sub-arterial roads or the highways towards the periphery. You will not have any major road bisecting this particular neighborhood or moving from within this particular neighborhood. And if you have a look at the roads closely inside the neighborhood, you will see that none of the roads move in a thorough manner. Okay, even if you see this particular road, it is not very straight. Okay, it goes something like this. This particular design of the road is to make sure that the traffic from these major roads are not coming within the neighborhood. Because what will happen if, let's say, there is some car over here, instead of moving like this, if it has to go somewhere here, it will try to bisect the neighborhood. But if the road is narrow, if the lanes are narrow, if it is not a straight road or a properly designed road for better speed, then they try to move around like that and not bisect it like this. So this was to ensure safety of the people and to ensure that there is enough pedestrian movement and cycle movement in this particular neighborhood. So that is with respect to your question 7. Neighborhood concept given by Clarence Perry. Okay, moving on to the next question. After establishment of the region for the purpose of Maharashtra Regional and Town Planning Act 1966. Now this is to do with, as you can see, MRTP Act of 1966, and it is asking us about region. So first of all, you should know what chapter are we talking about and what sections are we talking about. So here in MRTP under chapter 2, A, you have regions in which they are talking about establishment of region and alteration of its limits. Under chapter 2B, you are talking about constitution of Regional Planning Board. Now you are aware that whenever there is any act, there is always a formation of a board. Okay, so this is talking about all the details of the board. Under section C, you will get regional plans. So if there is a demarcated region, of course, there is going to be a regional plan that will be worked upon. Okay. Now coming back to the question which talks about the region and the limits. Okay, so establishment of region and alteration of its limits you will get under chapter 2A section 3. Okay, now let us read about each of these options clearly or carefully. The state government by notification in the official gazette. Okay, now the first one, alter the limits of a region so as to include therein, include, first keyword is alter the limit, so that is allowed, alter the limit so as to include therein or to exclude therefrom such areas as may be specified in the notification. Okay, the second one is amalgamate two or more regions so as to form one region. So amalgamate two or more regions to form one region. So you have to look at the keywords properly. Split up any region into two or more. So here we are talking about amalgamation of more regions into one. Here we are talking about splitting of any one region into two or more. The third one is declare that the whole or part of the area comprising of a region shall cease to be a region or part thereof. So any region or a part of that particular region shall cease to be a region. Okay, discontinue to be a region. So all of these provisions have already been given in this particular section. What all? It can be altered, or the region or the boundaries or the limits of the region can be altered to include anything in it or to exclude anything from it. Okay. The second one, two or more regions, can amalgamate into one. One region can be broken into two or more regions or split into two or more regions. And then there is a provision to declare that the whole or part of the area comprising a region shall cease to be a region. Okay, so all these provisions have been given. Let us look at the question now. The question says the limits of a region cannot be altered. We've already seen that it can be altered. Okay, so this is wrong. The next one, the region cannot be split up into two or more regions. We've already seen that under C, it can be split up. Okay, so cannot be split up. It's again wrong. Then the limits of a region can be altered so as to include therein or exclude therefrom such areas as may be specified in the notification. So this is exactly what your option A says. So this is correct. And then the whole or part of the area comprising a region shall not be seized to be a part or part thereof. We've seen in option D that that is also possible. So this not is wrong again. So the correct answer for 8 is option number 3. And where do we get it? We get it in MRTP. Sorry, let me write it from here. We get it in MRTP section number 3. Okay, so whenever you yourself are also solving any previous year question or any question, make sure that you write the act and the section. It will help you in revision. Okay, let us move ahead to question number 9. What are the duties of regional board? We just now saw that under the same chapter, A talked about region and B talked about the powers and duties and the establishment of the regional board. So let us read this question in detail. Duties of regional board: first, to prepare a regional plan, to prepare a development plan, to prepare a TPS, that is town planning scheme, or all of the above. Okay, this is mentioned in section number 8 of the MRTP Act. MRTP section 8, you will get these details. Okay. Okay. So let us read about it then. What are the powers and duties of the regional board? First of all, to prepare a regional plan. Okay. Second of all, to carry out any survey of the region and prepare reports on the surveys so carried. Okay. The second thing to do is to prepare an existing land use map. Of course, that will be the basis of creating or forming any regional plan. Okay. And D says to perform any other duties or functions as are supplemented, incidental or consequential to any of the foregoing duties. Okay. So here in all of these cases we are talking only about the regional plan and things associated to it. For example, the existing land use map of the region, survey of the region, prepare reports of the region and so on. So in this particular question, only one option talks about regional plan, that is 1. The second one talks about development plan, which is wrong. And TPS is also wrong. So automatically all of the above is also wrong. The answer for this is 1, to prepare regional plan. I hope by now you have a hang of what kind of questions are asked in MPSC or what kind of questions were asked in MPSC 2022 question paper. Okay, let's move ahead. Question number 10. When can the state government revise a regional plan after it comes into operation? So what is it saying is, the regional plan has already come into operation. Now, when can the state government revise it? At any time? At any time, but not earlier than 10 years. So 10 plus years. At any time after 10 years. At any time, but not earlier than 20 years. At any time, but not earlier than 5 years. So this is mentioned in section 20. In section 20 of your MRTP Act. Okay, what does it say? A state government at any time, a state government at any time after a regional plan come into operation, but can revise it, but not earlier than 10 years. So the answer for us is option number 2. Again, a very direct question being asked from your MRTP Act. Okay. The next one. The planning authority has to submit a report to the state government. Be very careful of who is submitting the report to whom. Okay. Don't mix up here. The planning authority has to submit a report to the state government about the progress made in carrying out the survey and preparing the plans as per section 21 of the MRTP Act 1966. So you already have the plan or the act with you and you already have the section with you. You need to tell whether the report is a monthly report, a quarterly report, half yearly report or yearly report. Okay. So in this section 21, it says that the planning authority has to submit a report to the state government and it has to be a quarterly report. So the answer for us is 2, which is the quarterly report. So as you've already seen, till now, questions have been asked directly from some report, act or some concept based, okay, like the proponent of a particular concept and what the concept talks about. Next. Any modification made by the state government in the draft development plan. Now we have moved from the regional plan to the development plan and the draft development plan is in question. Okay. So any modification made by the state government in the draft development plan to insert a new reservation on any land previously not affected is called what? Again, a very direct question in section 22. the provision given is of modifications of substantial nature. Okay, and in this particular provision, it talks about, first of all, insertion of new road, new reservation, or modification of a reserved site, or a proposed road, or a proposed road widening. Okay, so all this has been talked about in this particular section. The answer for us is 3, substantial nature modification. Okay, now we are talking about again MRTP Act and section 26 of this particular act. What does it say? Section 26 of the MRTP Act 1966 provides extension of up to how many months in case of municipal corporation, first keyword. Second, having a population of 10 lakhs or more but less than 1 crore, for extending the period of preparation and publication of notice of the draft development plan. So the section has already been given in this section 26 of MRTP Act. Okay, so in this there are 3 options being given in this particular section. It talks about the municipal corporation which has population of 1 crore or more. In that case, you have 24 months. You can extend up to 24 months. Okay. In the second one, 12 months. In case municipal corporation has 10 lakhs or more but less than 1 crore. So 12 months for this is 24 months for 1 CR plus, 12 months for 10 lakh to 1 crore. Okay, should not be 1 crore plus in this particular case, and 6 months in any other case. Okay, so 6 months in any other case. So whenever, again reiterating, whenever you are solving the previous year question, do not just stick to the correct answer, but look beyond it also. Read the section properly, read all the other options also properly, and what does it tell you? Okay, so in this particular case, 12 months for 10 lakh to 1 crore. So 2 is the correct answer over here. Okay, this is again a very direct question from the MRTP Act and section. Okay, so the planning authority shall submit the draft development plan to the state government for sanction under section dash of the Maharashtra Regional and Town Planning Act 1966. So the correct section over here is 31, which talks about submission of draft development plan. Okay. So 3 is the correct answer. The next question. Under the provision of Maharashtra Regional and Town Planning Act, in case the area falls in Metropolitan Planning Committee. Okay, we've already seen with respect to municipal corporation and the population that it has. Now it is to do with Metropolitan Planning Committee. Okay, dash period can be extended over the original period by the state government for sanctioning the draft development plan. So a similar kind of question, but this is to do with the Metropolitan Planning Committee. So under this particular section 31, you'll be able to see that 24 months can be extended in case area of such development plan falls in the jurisdiction of Metropolitan Planning Committee constituted under the Maharashtra Metropolitan Planning Committee. Okay, so for us the answer over here is 24. Okay, the next question again is from MRTP Act. Under the MRTP Act, a modification proposal made in the final development plan shall be deemed to have lapsed if not submitted to the state government within dash period from its publication to the official gazette. You have to read the question very carefully. What does it say? Under the provision of MRTP Act, so okay, we now know the act in question. A modification proposal made. Okay, modification proposal is made in the final development plan. Okay, shall be deemed to have lapsed if not submitted to the state government within how much time? So the answer is in section 37. Section 37 says that it should be within 1 year from the date of publication of notice in the official gazette. Okay. So the correct answer over here is 16. The answer is for 1 year. Let's move on to question number 17. Any applicant aggrieved by an order under section 45 of the Maharashtra Regional and Town Planning Act 1966 prefer an appeal to the state government or an officer appointed by the state government. Now we already know that this is in reference to section 45 of the MRTP Act. Let's directly go to the document. Here under 47 section, it's in reference to section 45. It talks about appeal. Okay, so let's read what it's written. Any applicant aggrieved by an order granting permission on conditions or refusing permission. So it is not granting permission that we are talking about. It is granting permission on condition or refusing it. So from these options, granting permission, refusing permission, both 1 and 2, and none of the above. So for us, the answer is going to be refusing permission. Had it been granting permission on condition, then we would have gone ahead with option number 3, which says both 1 and 2. Moving on to the next one. Within 1 year from the date of confirmation of notice under section 49 of the MRTP Act, it is necessary for appropriate authority to either complete the land acquisition procedure, make an application, pay compensation to the landowner, or publish a declaration under section 126(4) of the MRTP Act 1966. If you look at the details of section 49 of this act, you will find that the correct answer is make an application to acquire the land. Okay. The next one, a draft town planning scheme consists of draft town planning scheme. Okay. So in this, it's not written which act or document are we referring to. So here, this is in reference to the town planning scheme rules. Okay. Under that, if you see the section number 6, you will get the contents of a draft TPS scheme. Okay, it says, it gives you a list of n number of things that you have to give in the draft scheme. So an index map on a scale, and the scale is mentioned, area included within the scheme and surrounding lands within a reasonable limit, all existing roads, a plan on the scale of not smaller than 1:2500, showing the original plots with identification numbers. Okay, with identification numbers and all existing buildings and structures thereon. Like this, there are various plans or maps that have been mentioned that needs to be given. Along with that, you have a redistribution and valuation statement and a copy of estimates. So for our question, physical planning and valuation scheme only, physical planning and valuation of the scheme, physical planning of the scheme only, the financial aspects of town planning scheme, or none of the above. We've seen that it has to do with physical planning and valuation of the scheme. So the correct answer for question number 19 becomes option number 1. Moving on to question 20. Among the following options, select the correct option regarding the final plot of the town planning scheme. Again, this answer you will find in the TPS rules. Let us go through the options. It means the value of the original plot without reference to any improvement contemplated in the scheme. So it is directly talking about the original plot without any changes or without any improvements. So it cannot be the final plot. The second one, it is the result of reconstitution of original plot. So some work has been done on the original plot. Okay, reconstitution of the original plot and its areas and boundaries so as to render it more suitable for development purposes. Okay, this is the correct answer. Let us look at the other options as well. The third one says it means the original holding with well-defined boundaries, original holding with well-defined boundaries as found on the date of declaration of intention to make the scheme. Okay, so this is again wrong. No changes have been done on the original holdings and both 2 and 3. So again this is wrong as 3 is not one of the correct options. So the correct answer for us is option number 2. The next one, after sanction of a draft town planning scheme. Okay, after sanction of the TPS, all lands required by the appropriate authority for the purpose shall vest absolutely in the appropriate authority free from all encumbrances. And the options are the allotment or reservation of land for open space gardens and recreation grounds, or for social infrastructure, or the allotment of land for sale by planning authority, or allotment or reservation of land for water supply. So the correct answer here is option number 4. You will get the details of this question in Land Acquisition Act. Okay. Moving on to the next one. Question number 22. The role of arbitrator in TPS. So this is what you need to look into. So while we are at it, arbitrator, when it comes to that, you have to look into how he or she is appointed and what are the duties, what are the responsibilities and various other things that you will find in the MRTP Act. Okay, so here we are talking about the role of arbitrator in a town planning scheme as per the Maharashtra Regional and Town Planning Act 1966. Okay, and the role is to finalize the draft town planning scheme and prepare preliminary scheme only, to prepare preliminary town planning scheme and the valuation part of the town planning scheme is prepared by the tribunal, or to prepare the preliminary and final planning scheme, or none of the above. Let's look into this particular document of MRTP to find this answer. Under section 72 of this particular act, you will find the details of arbitrator, his powers and duties. Under this, it is written that the arbitrator shall, after following the prescribed procedure, subdivide the town planning scheme into a preliminary scheme and a final scheme. So the answer for us is option number 3. Prepare preliminary and final town planning scheme. Okay. Moving on to question number 23. Regarding the decision of the arbitrator, again this question is with respect to the arbitrator. So regarding the decision of the arbitrator as per section 72 of the MRTP Act, among the following options, choose the correct one. Okay, let us look at what's written in the document first. Section 73 with respect to section 72 will give you the details of certain decisions of arbitrator which is to be final. Under this, it's written that except in matters arising out of clauses 1, 2, 4, 5, 7 and 13. So apart from that, every decision of the arbitrator shall be final and conclusive and binding on all parties, including the planning authority. Let's read the options over here. Except in matters arising out of physical planning and some of the points regarding valuation, every decision of the arbitrator shall be final. Every decision of the arbitrator shall be final irrespective of everything. So this is unconditional in nature. The third one says arbitrator's decision shall be final and conclusive and binding on all parties except the planning authority. We already know that this is not the correct answer because here it says it's including the planning authority. The last one, except in matters arising out of some points regarding valuation. So in the first one, We were talking about points regarding physical planning and some points regarding valuation. In the fourth one, we are talking about only valuation. So we know that every decision of arbitrator is not final, since we are talking about a lot of clauses over here, and except planning authority is also not correct, because we have seen that it is including. Now the point arises whether we are talking about physical planning and valuation or valuation only. If you read into these clauses of section 72, you will find that all these points are with respect to valuation only. Okay, so the answer for us for question number 23 becomes, except in matters arising out of some of the points regarding valuation, every decision of the arbitrator is to be final. Okay, so for question number 23, we have option number 4 as the correct answer. The next question. For TPS, Tribunal of Appeals shall consist of. So this is talking about what it consists of, as in the constitution of the Tribunal Appeal. Apart from that, you have to look into the duties and responsibilities of that, and you can also see who appoints the people who are constituted into this Tribunal of Appeal. So under section 75, which talks about the constitution of the Tribunal of Appeal, it is written that it shall consist of a president and 2 assessors. Then moving on into this particular section, you will find the details of the president shall, who the president shall be, and also that the president shall appoint fit and proper persons as assessors. So we already know that the president is going to appoint the assessors. Coming to our question 24, it shall consist of president, yes, 2 assessors, yes, arbitrator, no. So the final answer for us for question number 24 is option number 4. Okay, the next one. The definition of semi-final value is the following. This particular answer you will find in TPS rules. Okay. Here it talks about the original value, the semi-final value, as well as the final value. Let's read what it says. Original value means the value of the original plot without reference to any improvement. Okay. This is with respect to no improvements contemplated in the scheme. Okay. The final value means the value of the final plot with reference to improvement. So the first one, original, is without any improvement. The final is with improvement. So what does semi-final mean? Okay, semi-final value means the value of the final plot without reference to any improvements contemplated in the scheme, other than improvements due to alteration of its boundaries, that is value of the final plot as a result of improvement in its shape. So we are only talking about alteration of the boundaries here. Okay, so let us read the options. It means the value of the original plot with reference to the improvements contemplated in the scheme, on the assumption that the scheme has been completed. So this is actually the final value. Okay. The second one, it means the value of the final plot without any reference to any improvements contemplated in the scheme. This is the original value as we have seen in the document. The third one, it means the value of final plot without reference to any improvements contemplated in the scheme, other than the improvements due to alterations of its boundaries or alteration of the shape. We have seen that this is the semi-final value. So the answer for us for question number 25 is option number 3. Okay. The next one, in estimating the value of increment, 1, the value of only trees, crops and wells shall be taken into consideration. This is wrong. Second one, the value of buildings or other works erected or in the course of erection on such plots shall not be taken into consideration. This is correct. Let us go through the other options as well. The value of only fencing and compound shall not be taken shall be taken into consideration. This is wrong, and none of the above also is wrong. So the correct answer is option number 2. Okay. Now we are talking about Gujarat. Okay. So the Gujarat government has made special provision in their Gujarat Town Planning and Urban Development Act, white section dash for local area plan. Okay. So this is directly the section that we are talking about. The correct answer is 76A. Okay. The next one, a local area plan is devised, okay, for greenfield development to improve and enhance the existing developed areas or for development of a region to define the use of land in the total area of planning authority. So we know that it is not the total area of the planning authority that we are talking. It's not the entire city. We are talking about the local area. Okay. The second one, development of a region, again, it is not correct. Region has a large spatial extent. We are talking about local area plan over here. So again, the third option is incorrect. Now, between greenfield development, which is any new development. The meaning of greenfield is any new development. And the second one is to enhance the existing developed areas. Amongst this, second is the correct answer. Local area plan is devised to improve the existing developed areas. Okay. The next one, if the provisions of local area plan are not consistent with UDCPR, in that particular case, what happens? A, then the provision of local area plan shall prevail. Then the particular shall be referred to the director of town planning, or the provisions of UDCPR shall prevail. The last one, the planning authority may propose for the modification under section 37 of the MRTP Act so as to stand it suitable for that particular provision of the local area plan. So if you go through these documents, you will know that the correct answer is then the provisions of the local area plan shall prevail. Okay. So the answer is option number 1. Now coming to question number 30. Special building means what? So this is a direct definition and it has been taken from UDCPR. Okay, you have to refer to this particular document to get the definition. Let's check what is written. Okay, so here special building means any multi-storied building which is more than 25 meter in height measured from the ground level, or it can be any education, assembly, industrial, institutional, storage and hazardous occupancy. Okay, and the built up area of 500 square meter is given. Okay, let's check the options here. Any multi-storied building which is more than 24 meter in height measured from the ground level, we've just seen under option number 1 that it is correct. Let's read through the other options as well. Building of educational, assembly, mercantile having built up area of 300 square meter or more, or any floor irrespective of the height, we've seen that this is incorrect. Okay. The third one, building for education, assembly, mercantile having total built up area 500 square meter or more, irrespective of the height of such building. This is also wrong. And the last one, any multi-storied building which is more than 24 meter in height, excluding parking floor up to 6 meter of height. Now, what is given to us is 24 meter of height. So, option 1 is correct in this case. Okay. So, the answer for question number 30 is option 1. This is for part 1. We'll be continuing with the questions in part 2 and 3.
KP classes dedicated to excellence.